Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. And in today's video, I'm going to talk about one of probably the most misunderstood elements when it comes to debt collection lawsuits, and that is the statute of limitations. When it starts, when it runs, and how you know if the creditor is outside the statute of limitations, and you can breathe a little bit easier. If this is your first time here to my YouTube channel, please click subscribe, check on that bell. That way you'll be notified each and every week when I put out new videos that'll help you deal with your serious debt problems. All right, let's talk about the statute of limitations. Just today in my office, I had someone come in and they had a judgment that was 14 years old. This was some old credit card judgment that had been entered, default judgment because they hadn't responded to it. It was 14 years old and the creditor was still trying to collect on it. They were trying to lien their property and cause all kinds of grief. And so, the person asked me, isn't this outside the statute of limitations? How is it that 14 years after this judgment has been entered, they're still trying to collect? They're still trying to, there's still interest accruing on it. The judgment was entered in 2008 for a debt that was like from 2003. We're dealing in decades old, this debt is, and they're still trying to collect on it. Now, the misunderstanding that a lot of people have is really what the statute of limitations is and what period of time that it applies to. The statute of limitations applies to the period of time from when the account goes into default, and then they give them a certain time period where they have to file the lawsuit. The way to think about it is essentially what the law says is, look, creditor, if this account goes into default, we're not just going to give you forever to file the lawsuit. You've got a certain window of time where you have to file this lawsuit, and if you don't do it within that certain window of time, then you're going to be barred forever from doing it. So like for instance, in Arizona, where I practice law, the statute of limitations on credit card debt is 6 years. So 6 years from the time when you stop making payments on the credit card, a 6-year window then to actually file a lawsuit against you. If they don't bring the lawsuit within that 6 years, they're barred forever from being able to do it. It's outside the statute of limitations, and even if they do sue you, the court will dismiss it because it's too old. They waited too long. Not only that, if they sue you after the statute of limitations is expired, you may have a claim against them under the Fair Debt Collection Practices Act, which is a federal statute that dictates how debt collectors can try to collect on debts. And essentially it says they can't do anything that's illegal. And it's not legal for them to sue you once it's outside the statute of limitations. So it's important to know though that the statute of limitations is different from state to state. Like for example, I stated in Arizona where I practice law, it's 6 years on credit card debt, where in other states it could be 4 years or 3 years or 2 years, or I've even seen it as long as 10 years on a credit card debt. So you need to know specifically in your state what that time period is. Now the statute of limitations it does not refer to the time after a judgment is entered. So like this gentleman that came into my office this afternoon, he had this judgment that was 12 or 14 years old. The 6-year statute does not apply after the judgment has been entered. Once the judgment's been entered, then a whole different statute, at least in the state of Arizona, applies. For example, in Arizona, civil judgments are good for 10 years, and then they can be renewed every 10 years for the rest of your life. So if we're talking before a lawsuit is filed, there's a 6-year window for them to file a lawsuit. If we're talking after a judgment has been entered in Arizona, they have 10 years to collect on it, and then it can be renewed every 10 years forever. So when you're talking statute of limitations, we're talking before the lawsuit is filed. From the time the account goes into default, essentially when 30 days after payments stop being made on it, they have 6 years to file the lawsuit, and then if not, then they're barred forever from doing it. Now, there is an important distinction that I like to bring up because it can be used to your benefit, and that comes to as far as how the statute of limitations works, at least in Arizona, as it applies to installment loans. An installment loan is different than a credit card. In a credit card, you charge it, you pay it off, you charge it, you pay it off. It's this fluctuating balance all the time. An installment loan is more like a car loan or a student loan where there's a specific dollar amount that you have to pay each month. There's $262 and it's due on the 15th of each month, and you pay that for a set period of time, like 20 years or 10 years or 30 years or whatever it is. Arizona law says that each of those individual monthly payments has its own statute of limitations. So for example, if you have a 10-year installment loan, each year there's 12 individual little time periods where a payment is due because there's 12 monthly payments. So the statute of limitations applies to each of those individual payments. So when I have a client who comes in and they're being sued, usually on on like an old student loan or an old car loan, it's possible, and it may be, that any of those installment payments that were due more than 6 years from the time when the lawsuit was filed, because it's that 6-year statute of limitations. So I look at the date that the lawsuit was filed, I go back 6 years, and any of those installments that were due prior to that 6-year period are barred by the statute of limitations. So it immediately throws out a big chunk of what they're claiming is owed. Not only that, again, it opens them up to the creditor of Fair Debt Collection Practices Act, FDCPA. It opens them up to some liability there. So that's just something to be aware of with installment loans, because they are a little bit different and they can give you an edge as far as, even if some of the payments are within the statute, it may be, but a good chunk of them are not, and you can get those thrown out completely. So one other final thing on statute of limitations. If you are getting letters from a debt collector, it's always important to look very closely at the language, the fine print on both the front and the back of the letter. Because if you're getting a letter and you're thinking, man, this thing is super old, it could be that it's outside the statute of limitations. Now, going back again, that FDCPA law, the Fair Debt Collection Practices Act, requires, if the debt is outside the statute of limitations, that the creditor actually has to put a little statement on there that says that it's beyond the time when they can actually file a lawsuit against you, but they're asking you to voluntarily pay it. That can go a long ways as far as determining whether you should actually engage that creditor and try to settle it or pay it off because you're concerned that a lawsuit may be pending, or if it's something that's outside the statute of limitations and either you're choosing not to pay it, or it's something where you may get a much lower settlement because of that. So hopefully that clears up some of the issues with statute of limitations. If you're in the state of Arizona, please contact me if you're getting sued by a debt collector or you're looking at bankruptcy. I deal with all things consumer debt in the state of Arizona. We do free consultations where I'm happy to talk to you and kind of go over your situation. Appreciate you watching today.